last session on international arbitration. So, since the beginning, we have been looking into the arbitration proceedings and the arbitration hearings and the arbitration agreement, of course. So, end of all these proceedings, the arbitration award, which is the one the parties are looking for. So, in this session, we will be looking the essential elements of arbitration award to be incorporated, along with uh, along with an example of actual arbitration award. So first, uh, arbitration award, as you all know, arbitration award, it is a final and it is a binding decision made by the arbitrator, that is who has been appointed by the parties. He makes a final and binding decision on the dispute which is being referred by the parties to be adjudicated. So whatever the arbitrator gives as a final award, it will be the final decision upon the dispute which is being referred. So there will be no other further adjudication for that dispute referred. So now an arbitration agreement, because of arbitration agreement, a dispute has been referred to arbitrator, and with all the hearings and documents submitted, the arbitrator has passed his award. And so to pass this award, there is some timeline which the arbitrator has to strictly comply with. This timeline varies from country to country. If it is UAE, the timeline should be, it can be agreed between the parties. If it is not agreed between the parties, then it will be, as per the law, it will be 6 months from the date of first hearing, that is the preliminary meeting. So this 6 month, if the arbitrator is not able to issue the award because of some issues like delay by the parties or some kind of issues, so in that situation, the parties, by having an agreement, they could extend this 6 month timeline, or if not, they could approach the court if the parties are not mutually coming together to agree to this extension of time. Then they could approach the court and request the court to extend this timeline. So if it is UAE, an arbitration proceeding is conducted in UAE, the timeline will be 6 months and it can be extended further. So if it is in India, the arbitrator has to make the award within 12 months from the date he enters into the reference. Of course, the date of first arbitration hearing. So this 12-month, obviously, it could be extended for another 6 months, similar to UAE arbitration law. Um, uh, by mutually, the parties could mutually agree on this extension timeline. If not, they could again approach the court for the extension of timeline. So whatever the timeline, the arbitrator has to strictly stick to that timeline and pass his award. He has to conduct the proceeding accordingly and pass the award. And next is UNCITRAL and UK arbitration law. So this UNCITRAL does not speak on the timeline, but the countries, they have their timeline in their arbitration act, and the arbitrators do follow those timeline and pass the award. But in UK, and as I said, UNCITRAL does not have any strict timeline. Although the parties can have it in their agreement, and the arbitrator has to, if it has been mentioned in the arbitration agreement, then the arbitrator has to stick to that timeline. Also, if they are approaching any institution for the appointment of arbitrator, so the institution rule, for example, if it is ICC, or some other institutions like CAAC, so they have to check the rules whether it has a specific timeline for the arbitrator to pass the award. If it is mentioned, obviously the arbitrator has to pass the award within that time limit. So next, let us see what are the types of award. We have been saying that arbitration award is the end of the proceedings, arbitration proceedings. So let us see what are the types of award. The final award is the final one. Before that, the arbitrator will pass some other orders and awards. So let us see what are those awards and orders. First one is interlocutory order. It is also called as a preliminary order. Sorry, preliminary order. The arbitrator will be addressing the preliminary issues like jurisdiction, his jurisdiction, whether he has the power and authority to adjudicate the matter, or so that kind of things will be addressed, and it will be adjudicate. I mean, it will be verified by the arbitrator, and he will be passing an award in this interlocutory award. So this interlocutory award, it deals with the preliminary issues relevant to the claim of the parties, but not with the actual claim themselves. So it can be like the applicable law, that is the contract law of which country has to be followed, and of course the jurisdiction of the tribunal, whether he has jurisdiction or not. So that kind of things will be addressed in this interlocutory award. Next is interim award. We have been discussing about this interim award I mean, since the beginning of our session. Yes, if the parties, if they need any provisional or some temporary relief before ending this proceeding, so the parties could approach the arbitrator for that relief, and the arbitrator, after examining all the documents and evidences submitted, he could pass the interim award. So this interim award, it is subject to further revision by the arbitral tribunal, and are only enforceable and are only enforced, until a final decision is made in regard to the relevant claim. So this interim award, as the name says, it is a temporary award. So until the final decision is made. Next is partial award. The arbitrator, he has the power to pass a partial award. That is, pass an award for some issues which has been raised by the parties. So these issues may deal with liability, or the quantum of damages or compensation to be made. So that kind of issues he could make a partial award, not actually adjudicating on the dispute referred. Next is, yes, final award. So with this final award, the arbitration proceeding comes to an end, and this final award, it is binding, and as the name stipulates, it is the final award. So this final award, it could be subject to a challenge petition by the opponent person, and of course, it can be enforceable through court proceedings. Next is consent award. You could have heard this, I mean, type of award in our previous sessions. So you have initiated the arbitration proceeding, but the parties, they are very much willing to settle the matter by mutually negotiating and discussing, and they want to settle the matter. So in that situation, they could request the arbitrator, saying that we are willing to settle this matter, and you please pass an award. So if such kind of request is made by the parties, so the arbitrator, he has the power to pass an award, that is called as award by consent. So in this award, there is no need for the arbitrator to mention the reason of the award. So the consent award, it has the advantage, because it has the major advantage, because I mean, it is highly enforceable than the final and other kind of awards. So this consent award, it could not be challenged by any of the parties. Um, yes. So the award by consent or capable of enforcement, just as any final award. Next is the form of an award, that is the critical elements that has to be there in the award to make it as an enforceable one. Yes, the arbitral award, it should be in writing. And the oral award, it is not allowed in any of the country. Of course, the ancestral also does not allow the oral award. So mandatorily the arbitral award should be in writing. And next is, it has to be signed by the arbitrator. If it is more than one, three, or five, then it has to be obviously signed by all the arbitrators. If a situation arises that if one of the party, sorry, if one of the arbitrator could not sign the arbitration award, so he could excuse and give his reason why he's not signing the award. So it has to be mandatorily signed by the uh, all the arbitrators. Only then the award could be enforceable. It could attain the status of enforceability. Next is the arbitral award. It should state the reason. The arbitrator should state the reason why he has given this kind of award. If it is consent award, there is no need for him to mention the reason of the award. If not, if it is based on the decision by the arbitrator, that award should answer all the issues with a reason. And the date and place of arbitration, uh, you may look it as a simple one, but this plays a crucial role while filing the enforcement petition as well as the challenge petition. So the date and place of the arbitration, it should be critically mentioned on the arbitration award. And next is, the delivery of arbitration award to the parties. That is signed copy of arbitration award to the parties. So once the arbitrator, he passes the award, uh, he should make sure that the copies are duly delivered to the parties. That is, the parties get the copies by their own. It has not been delivered to their some random persons or their advocates. He should make sure, the arbitrator should make sure that it is properly delivered to the parties. So we have been seeing many arbitration acts, that is UAE Arbitration Act, Indian Arbitration Act, ancestral arbitration law. Even though, I mean, there are many laws, there is no strict format for the arbitration award uh, apart from the writing requirement. So So let me point out what are the essential things to be there in the award. Of course, the arbitration award should be in writing. It has to be signed by the parties. It has to be signed by the arbitrator, and it should include the reason of the award, why it has been, why the arbitrator has given this award, maybe in favor of the opponent or the claimant. So that reason has to be there, unless until it is a consent award. And the place and date of the arbitration, it has to be there, and the signed copy of the arbitration award, it has to be duly delivered to the parties. So now let us see an arbitration award, like how it has to be drafted in case of any dispute. So this will be the front part of the arbitration award. It starts with in the matter of between the claimant name, address, and the respondent's name, address. It has to be proper to make sure that, I mean, to make sure that the claimant and the respondent's name and address are proper and clear. Next is arbitral tribunal name and the date of award. So these things will be in the front page, first page. Next is arbitration award. That is, first there will be an introduction part and the procedural history part, followed by that the facts of the case and the issues to be determined, and at last the award part will be there. So let us look into these parts each and this introduction part. The arbitrator will be narrating the introduction, that is the dispute between the parties. So in this case, this arbitration arises from a dispute. He has mentioned about the dispute based on the contract reference number, date, everything is mentioned here. and the arbitration or conducted under the rules of so and so pursuant to an arbitration agreement contained in the arbitration clause of the contract between the parties, and the seat of arbitration and the governing law of the contract is also mentioned here in the introduction part. Next is procedural history. That is, the whatever things which has been happened during the hearing stages, that will be mentioned, that will be recorded in the arbitration award. Because I mean, in case of if in case the either of the party or challenging the arbitration award, saying that he was not given a proper opportunity to represent his case. So in that scenario, if these procedural things are already mentioned in the award, then this can be placed as an evidence saying that every party has given equal opportunity to present their case. So in the procedural history, the claimant initiated arbitration by serving a notice of arbitration. The date is mentioned here, and seeking relief for so and so. The respondent submitted its response to the notice of arbitration, and the arbitral tribunal was constituted on the so and so date is mentioned. And whatever the notices and the submissions made to the parties, whether it is mail or through post, everything will be recorded in this procedural history itself. The procedural meeting was held on it was, and the notification regarding this meetings will also be included in this part. The parties exchanged written submissions, so on so date, everything is mentioned here. So if you are an arbitrator, you make sure that all those submissions, date, and the delivery proof, everything is clearly stated in this part, so that your award is not subject to set aside. And next, the facts of the case. So whatever things happened relevant to the dispute, based on the submissions by the parties, the arbitrator will be recording in this part. That is, the facts of the case will be narrated based on the chronological manner. Here, the claimant nature of business is mentioned here, is a manufacturer of so and so. The contract stipulated that the goods, in this dispute, that there was a contract between claimant and respondent, and the claimant is supposed to deliver some kind of good to the respondent. The respondent got the good, but he didn't pay the amount. Hence, the claimant has initiated an arbitration proceeding, saying that he wants the outstanding amount, whereas the respondent states that the good delivered was in defect, so because of which he didn't pay the amount. So this is the facts of the case. So it is being clearly mentioned in this arbitration award. So here the claimant alleges that the respondent failed to pay contrary to the terms of the contract, and claims the amount of so and so plus interest. The respondent contends that the goods delivered by the claimant were defective. The opposite person, he contends that the goods was defective, and because of which he didn't pay. He has withheld the payment. The respondent also raises a counterclaim. He also makes his claim for damages because of defective good delivery. So in this part, the arbitrator records the issues whichever has to be determined. In our earlier session, we had discussed that there will be a hearing to finalize the issues, that is the questions whichever has to be answered by the arbitrator in the award. So that will be listed, and it is called as issues. So that issues is being listed in the arbitration award. Here the issues are whether the respondent is liable to pay the claimant the amount claimed for the delivered goods. Next issue is whether the goods delivered by the claimant are defective, and if so, whether the respondent is entitled to damages as claimed in the counterclaim, and the quantum of damages, if any, payable by either party. So there are three issues in this arbitration award. So every issues has to be answered by the arbitrator in the award, along with the reason. So here, liability for payment, the tribunal finds that the claimant delivered the goods in accordance with the specifications detailed in the contract as evidenced by, he's referring to the evidence submitted by the claimant here. And the respondent's failure to make payments for the goods received constitute a breach of contract, as per the clause of the contract. Therefore, the tribunal holds that the respondent is liable to pay the claimant the amount of so and so for the delivered good. For this specific issue, he has given his findings based on the submissions by the parties. Next is the defectiveness of goods, that is the issues by the respondent here. The tribunal finds that the evidence is provided by the respondent, including he has mentioned the evidences submitted by the respondent. So that does not sufficiently prove that the good delivered were defective as claimed. So the respondent's counterclaim for damages is therefore dismissed. So here the arbitrator states that the respondent's claim for damages because of defective good delivered is not proved, and it is not substantiated. It is not being proved by the respondent with proper documents. Hence, he rejects the uh, respondent's statement. Next is the quantum of damages. Having determined that respondent is liable for the unpaid invoices and that the counterclaim fails, the tribunal orders that the respondent pays the claimant the sum of so and so plus interest at the rate of per annum until the date of award. So all these three issues were answered by the arbitral tribunal with the reasons based on the documents and the evidences submitted by the parties. So this is the final part of the award, wherein the arbitrator as given is the actual award. That is the final award. So the respondent shall pay the claimant the sum of rupees as under the contract together along with interest at the rate of until the date of payment. Next thing is the respondent's counterclaim is dismissed in its entirety. So he has already rejected the claim of the respondent in the issue part itself, even though he has to mention in the final part of the award. Whatever the decisions by the arbitrator, he has to mention in the final part of the award. And the cost of arbitration, the claimant could have mentioned is, could have claimed the cost of arbitration. So that thing is answering including the fee of the tribunal, shall be borne by the respondent. The tribunal fixes the cost of so on. So the cost of the the arbitrator's fee, other reimbursable cost, he has allowed in favor of the claimant here. So all other claims and release sought by the parties not expressly granted herein or dismissed. And next is this is the conclusion part of the award. So here it is mentioned that this award is final and binding on the parties, and the arbitrator, he will mention, he will sign along with the date and the name, place of arbitration. Everything will be mentioned in the final part of the award. So if you're making an arbitration award, you make sure that all things, whichever, all claims, whichever raised during the arbitration proceedings, though it is superfluous, you make sure that all those things are mentioned in the arbitration award. Whether you accept or reject, whether you allow or reject, you make sure that you answer to those issues and claims. So let me show another arbitration award, the actual one. So this is an actual arbitration award. The dispute here is it is a loan default case. Tata Capital, they have lended some loan to Mr. Sanjay Parikh. So we have mentioned before the arbitral tribunal constituted by so and so. The arbitration case number is mentioned here, and the loan account number. If it is contractual dispute, yeah, that contract reference will be mentioned here, and the date of award is mentioned here. In the matter of the claimant detail and the respondent detail is mentioned here. So in the first part, the claimant detail and the nature of business and the respondent detail, their work, everything will be mentioned here. So whatever the documents being submitted by the parties during the arbitration proceedings, that will be marked as exhibits, so and so 1, 2, 3, or A B C D, something like that, and it will be referred in the arbitration award. Yes, sir.
Madhu, someone says they can't hear.
So you can hear me,
Oh,
right?
yes, I can hear. Arush says, is it the case with everyone or only for Arush? Okay, now it is fine. Okay, kindly proceed, Madhu. I think now it's fine, she says.
Okay. So my present, I mean, the PDF is visible, right, sir?
Yes, yes.
Okay, so whatever the documents submitted by the parties during the arbitration proceedings, that will be marked as exhibit, and it has to be referred by the tribunal in the arbitration award. So here the copy of NCLT order is marked as exhibit, and it has been referred as so and so in the award. And the factual thing is mentioned here. The respondent approached the claimant for financial assistance, and the claimant has given the loan. The loan agreement is mentioned here, and the loan availed, that is loan lender, was mentioned here, 1,28,000. The interest rate is mentioned here, and see here, the dispute arose between the parties and the respondent in respect of the loan agreement data. Hence, the claimant invoked the arbitration clause contained in the said agreement after exhausting the pre-arbitral steps. So, the date of reference to arbitration is mentioned here. Issued a letter. This dispute was resolved through online dispute resolution, that is ODI platform. So, that thing is mentioned here. Also, in this case, the claimant, that is Tata Capital, they asked for some interim relief, that is to freeze the respondent's bank account. So that petition is also mentioned here. The claim petition and the interim application. And the date of first hearing, second hearing, and the issuance of notices to the parties, notifying the hearing date, and uh, meeting links is also mentioned here. So in this case, the respondent was not appearing in spite of all notification regarding the hearings and asking him to submit his statements, that is written statements. He was not present. Because of his absence, the award was rendered as ex parte based on the documents submitted by the claimant. So the documents whichever been marked in this proceedings were listed out here, and the issues uh, which were finalized in this proceeding are listed out here. And for every issues, the tribunal has given its decision along with the reasoning and referring to the documents submitted by the claimant and the parties. So for every issues, the arbitral tribunal has given its decision along with the reasoning. And finally, the award and the direction by the tribunal is being mentioned here. Rate of interest. And it has been signed by the arbitral tribunal. and delivery proof is mentioned here, and the date of arbitral award is also mentioned here. Let me present another arbitration award so that you can understand much more. Sir, can you see this award?
Yes, Madhu.
Yes, sir. So in this award, the name of the arbitrator and the case number is mentioned here. The party's detail, everything is listed here. And this arbitration proceeding, and the appointment of arbitrator came through the court, that is Madras High Court. Hence, the
Sun,
Madras High Court order. Yes, sir.
it shows
Yes,
section
sir.
33
Please.
application.
Sorry, sir. Yes. So this is another arbitration award. The arbitrator here is Mrs. Sucharita. So her name is mentioned, and the date of award is mentioned. The case number is also mentioned here, and the arbitrator appointment in this case, it came through the court. That is the court, the Madras High Court appointed the arbitrator. Hence, that order is also being referred here, and the preliminary meeting, the date, everything is mentioned, and the facts of the disputes, that is the claim and submission. These are the facts of the disputes. It has been recorded here. These are the prayers of the claimant, and the hearings. After the preliminary meeting, all the hearings were conducted virtually. Hence, that is also being recorded here. Whatever things happened in the hearings, it is being recorded in the award, and the issues finalized with the presence of the parties is being included here, and the exhibits, that is the documents which have been marked during the proceeding, is also included here, and every issues, it is being answered with reference to the documents and the law, that is Indian Arbitration and Conciliation Act or the Contract Act of the country. With reference to that, it has been answered by the tribunal. So in this case, the claimant initiated the proceedings, and the respondent, though he was present during the hearings, he didn't submit any of the documents. So hence, he waived his right to object, obviously. So that thing is being mentioned here, along with reference to the uh, Arbitration Act. So every issues is being answered, and finally, the award, the directions to the respondent is being mentioned on the end of the award, and the signature of the arbitral tribunal and the date of the award. Hope you had got some idea about drafting an arbitration award.